Good afternoon, Will. How are you?
Good afternoon, Damien. Very well. Thank you very much for inviting me back on our part two of what seemed to be quite a contentious. Certainly got feelings going, didn't it? Part one. So
It certainly did.
more to come then. More to come.
Definitely more to come. It's going to be an interesting conversation.
Yeah,
So what have you been up to?
yeah. Lots going on, and but actually, and we'll bring some of these things up in this part, but yeah, I put a video out recently actually centering more on natural law and morality and how that links with the Constitution. And so there are plenty of topics that are going to come up in this in towards that. So yeah, so we've had plenty of that going on in the last week and a half or so. So yeah.
Brilliant. Well, I've just been carrying on reading, to be honest, getting into the Glorious Revolution.
Yeah.
So I've done a bit further reading actually past what we're going to be discussing today to prep for part three.
Yeah.
So it's
Good.
been busy, 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 and lots more interesting points have come up.
Actually, we should say that, shouldn't we? Because we thought we were sort of hinting, weren't we, last time that there would probably be three parts, but we now think there are going to be four. That's because it just keeps getting bigger and bigger.
It's
Um,
definitely going to be four now, I think.
yeah, yeah,
We can get into that if you're ready.
yeah. Fantastic. Let's do it.
This is the background on what we're going to be talking about. The birth of James Francis Edward Stuart and the warming pan scandal. The case of the seven bishops who refused to read out Declaration of Indulgence. Was it conflicted with statute law? Parliament believed the king didn't have the authority to dispense with statute. Two cases relevant to the trial of the seven bishops. So we're going to be looking at Godden versus Hales and Thomas versus Sorrel or Sorrel.
Yeah,
A brief look at Edward Cook's views on the king's ability to suspend and dispense with statute law. The non-jurors, as they became to be known, which was five of the seven bishops who originally petitioned the king over the
yeah,
Declaration of Indulgence. The Immortal Seven, who were they, what were their intentions, and a brief look at their moral character.
yes,
The Letter of Invitation, who was behind it, what did it say, what purpose did it serve, implications. And then finally, we're going to end on William of Orange's Declaration of Reasons. Again, who was behind it? What did it say? Purpose, implications,
yeah. That was his justification, wasn't it? Really, to
and justification. Yeah.
yeah, exactly. Great. Yeah. So that's the scope of of today's part. That's your curriculum, viewers. That's what we're going to be covering. There you go.
So this is
Yes.
James Francis Edward Stuart, born on the 10th of June, 1688, and a male legitimate heir.
Finally,
Yes.
right at the last minute, which
So
threw things into chaos. They were hoping at this point, just before that, we get into that, that this was going to remain a problem, that there was no male legitimate heir. And yeah, that was this was the thing that triggered or was the last straw, wasn't it, really, I suppose?
I think this was the threat to Mary's right to the throne. I think this
Yeah,
is what got William's attention.
yeah.
Although William had already decided long before.
He was still going to take
He was
action, and
still going to take action.
right.
He'd made final plans by April,
Yes, that's important.
like a couple of months before James was even born. I think it is important to state that this didn't trigger the actual invasion. It was
No,
already in motion.
but it was an added incentive, wasn't it? It was kind of like the last straw. Just
Yeah,
like,
definitely.
yeah, definitely. Yeah.
The Prince of Wales was born on the 10th of June, 1688. He was named James Francis Edward in honour of his father, of the Queen's favourite saint, Francis Xavier, and of Saint Edward the Confessor, the Saxon king who James revered. The threat of a Catholic dynasty became a reality, and unfortunately, James, Mary Beatrice, and the young prince became a target for the most outrageous claims. James's rivals latched onto a claim that the Prince of Wales was superstitious, and the warming pan myth was born. The claims varied, and stories of a fake pregnancy spread like wildfire. People suspected that Mary's bump wasn't real. Others claimed that Mary had miscarried early on in her pregnancy or as late as the birth. Regardless, the consensus was that a baby was smuggled into the bedchamber in a warming pan to be passed off as the Prince of Wales. What is more disturbing is when one discovers who was giving credence to these deeply hurtful claims. You would expect self-interested Whigs and Tories to play some part in the propaganda, but James's own family. Sadly, William of Orange, Mary, and Anne was central to the lies.
Just awful. Yeah, it's extraordinary, isn't it? But I suppose as we want to demonstrate now is that there was plenty of legitimacy to that birth, plenty of evidence, plenty of of commentary and witnesses and all the rest of it. So we've got various things to show, haven't we, in the way of
Yes, we've got
references and quotations for that.
How could anyone seriously believe that such a fond father as James would oust his beloved daughters from the succession just to put a changeling on the throne? The whole business of casting aspersions on the Prince of Wales's birth, pretending that someone else's child had been smuggled into Queen Mary Beatrice's bed in a warming pan for the royal couple to pass off as their own, was just a convenient fabrication of the Protestants. It was the pretext William needed for his unlawful invasion of his father-in-law's kingdom. And the second one, that was actually from Ungrateful Daughters by Maureen Waller.
Yeah. Interesting.
So the second one, it was this Protestant predisposition to refuse recognition to a Catholic heir, not any irregularities in the birth of Prince James Francis Edward on the 10th of June 1688, which occasioned the convenient, though palpably crude and preposterous fiction that the infant was a supposed child, smuggled into the Queen's bed in a warming pan. The fabrication is as clear an instance of Protestant superstition as history affords. I think this was Ken Bedard,
right?
The Kingdom Without a King, which is a really good book.
Interesting.
And the last one is who we've touched on before in the first part. It's Lucille Pinkham in The Respectable Revolution. And she said, "No one today questions the Stuart blood of the old pretender, but that was not so in his babyhood. Nevertheless, the stories which ripened into outright accusations after his birth were the result of planned activity rather than of spontaneous suspicion. Similar insinuations had been spread some years earlier, preceding the birth of Mary of Modena's third child. Now they appeared again. The whole story is revolting, and one would prefer to pass over it in silence. In the silence it would deserve, were it not for the part the whole affair played in ensuring the success of the revolution."
Yeah. Yeah, she was one of the earlier writers in this century, wasn't she, to sort of kick against the narrative, one of the more dissident writers early on. And she got a lot of grief for it. We talked about that before, didn't we? So here we go. So this one is from the essay that we looked at a little bit last time in the first part, Dennis Barton, which is an online essay that you can get to on the website Church in History, and that's the link, but we could put those out. So there had been rumours of a miscarriage at 6 months, but everyone at court knew that they were unfounded. The actual birth was witnessed by the Queen Dowager and several lords and ladies, both Catholic and non-Catholic. and members of the Privy Council. Many of the ladies stood around the bed. Sounds a bit interesting. Few royal births have been more fully documented, and at a special meeting of the Privy Council, testimonies were given by the midwife and laundress, of all people. So there were various references in that, which actually are down here. So this is Dennis Button referencing other books. So one of them, James II by Jock Haswell, 1972. And the second one, The Glorious Revolution of 1688 by Maurice Ashley, 1966. So that is quite an interesting demonstration of everyone being involved, the Privy Council, down to the laundress. So we got one other actually, which might be interesting. So let's grab this one. Yeah, this is interesting actually. So if the claims that the monarchy was hereditary and not elective, and that the throne was not vacant, could both be upheld, both those two things,
Yeah.
then Mary's supporters were convinced that she should logically succeed. The trouble with this logic was the birth of a son to Mary of Modena the previous June. Although most peers and MPs seemed to have preferred to ignore his existence or assumed, in a paradigm case of what psychologists call dissonance reduction, you can see this is my kind of stuff.
Wow.
That he was supposititious. So she's actually referring there to almost a, or WA spec, I should say, is referring to a mental condition. Yeah, I definitely talk about this kind of stuff normally, don't I? He clearly complicated the issue. It is significant that the convention never investigated the circumstances of his birth, even though William had referred the matter to Parliament in his declaration. We're getting ahead of ourselves a little bit here. An inquiry was started, but was dropped on the grounds that the child, being in France by that point, made it impossible to establish the truth. So what I thought was interesting in that was this cognitive dissonance, essentially, just thinking that we don't really want to go here. We don't want to look at it. It's the elephant in the room, but we're just not going to talk about it at all. We're not going to give it any kind of acknowledgement, So that was W.A. Speck, Reluctant Revolutionaries, Englishmen and the Revolution of 1688, Oxford University Press. Now, what's quite interesting is the footnote here. There's no room for the examination of the little gent's title, which perhaps will be hereafter the best proof he has of his title, that after 'twas in their power to examine his birth, they durst not refer it to a free parliament, as was pretended. So there you go. So there's a footnote that's being referenced from it was a Tory who wrote to Oxford, 7th of February 1689, in the Bodleian Ballard manuscripts. That's a collection of manuscripts in the Bodleian Library. So that's the raw source of that. But what is interesting is the fact that he's hinting at there that people just didn't want to make reference to this. It was so kind of shameful. And yet they just didn't, or the ignoring of the fact that the birth was real, but they just don't want to go there. It's the cognitive dissonance aspect of it that I just wanted to bring up there, because I think that really, really points to that.
What I wanted to touch on, Will, briefly, after those quotes that you've just read out, is what do you think of the whole hereditary succession and how that was dealt with this? Because James was a legitimate heir. There's no question about it. And it was an hereditary.
Yes, it had become a hereditary convention, rightly or wrongly. Well, wrongly actually, shouldn't necessarily be assumed, of course. And that's where, by the time we got to the Stuart Kings, things had gone wrong, and that was a characteristic of the divine right of kings, if you like, that was not constitutional. If you take the authentic constitution as it really was, back in the late Saxon times and the way it was understood then no, it's not an assumed thing that it's hereditary and it just automatically passes down, and but that certainly was by this point. So even under their understanding of the Constitution at that point, and they're sort of hinting at that they do think that James's son was legitimate, and obviously James himself was legitimate. So there's no leg to stand on that one. So yeah, it was a current convention that they actually regarded. In fact, it's interesting if you look back at the history of the break of the lines of the kings, of the monarchs, it gets much more untidy, way further back, and it tidies up much more after the Norman conquest, because the Normans came in and basically they felt that was a line of kings. They had that divine right. So they started to adopt that way of thinking. And then as you got into the Plantagenets, it was just absolutely became entrenched as an idea. So by the time you got to the Tudors and then the Stuarts, that was the way it was. It was considered that English kings would pass down like that, and that was where the legitimacy came from. But it's not really wasn't really meant to be considered a standard like that. What it should be is a kind of an elective thing, but almost by resistance. So if it was going to be proposed that the son would take over, then the people would, if they didn't agree, then would rise up and make their feelings known, and if that was the case, they would get themselves a different king. And that sort of quotation, you can see that in references, just that line being talked about in history. We will get ourselves a different king if a king steps out of line. We'll find another king. Thank you very much. That was the sense of it, much more back then. But this became established and entrenched, definitely, and certainly by this point, it was that was sort of part of encapsulated within that sort of divine right of kings package, if you like, along with one or two other things that weren't right as well, which we can get into.
It's hard to understand how they got round it legally, with it being, established in law that it was a hereditary monarchy. There's talks of, James being superstitious and James II actually vacating his position, as you just touched on.
Well, that's the only way they were able to do it, wasn't it? Because they believed in the hereditary line. Then the only way they could do it is pretend that James Edward didn't exist and that it was introduced the warming pan thing, and so the lies became more absurd simply because they knew they had to go to extreme lengths in order to deny it.
You talk about it being a bit of a mental thing as well.
Yeah,
it's like the bigger the lie, the more people will believe it.
You're adopting doublethink and cognitive dissonance, and you can always see that behavior when you're starting to get outside morality, when people are not being honest with themselves. It just gets more and more extreme.
Even when you're presented with the clear evidence to the contrary, people still believed it. Like I read a couple of things. I haven't included it on my quotes, but the midwife, I think it was a Miss Dawson, I'm pretty sure it was Miss Dawson. Right. She actually addressed the warming pan because she said she brought it in with hot coals.
Right,
there's no way there could have been a baby in there. Certainly not a live baby.
Well, and she was testifying to the Privy Council that this was the case. And
I'm not sure whether it went to the Privy Council or this was a comment between her and Princess Anne or Mary, possibly, or a letter.
Yeah.
And there was another couple of quotes that I read that I found, because it was everybody. Even the doctor that James called to attend was a Huguenot.
Oh yes, was a Protestant. Yeah, exactly. Yeah.
And he actually wrote to Sophie of Hanover trying to quash some of the rumours
Yeah.
by saying, why would James, I'd probably be the last person he would call if there was some sort of Catholic conspiracy
Yes.
to use his absolute power to turn the country Catholic.
Yeah. Yeah. So a lot of inconvenient testimonies and truths coming out.
The other one was an artist who regularly painted Mary and James, and he was basically saying, I can paint them without actually looking at them. I know that well. It's ingrained in my mind. And he was like, that baby is James's and Mary's 100%, even
Right.
down to the fingernails.
Yeah, that's interesting. Wow. Okay. Yeah, it's all pretty dodgy stuff, isn't it? It's just more. Um, we're continuing to paint the picture here of the sort of the lies and the disinformation and the stirring and the smoke and mirrors that is going on.
I think it's
Um,
similar to
but,
what we were discussing in the first part. We were going down this line. You know, a lot of people like bending the truth or
yeah,
attempting to bend the truth.
yeah, yeah, absolutely.
There's another couple of quotes. Like I found the first one pretty funny, to be honest. It could not have been more public if he had been born in Charing Cross, and that was Bishop Atterbury
Yeah,
talking about the birth of the Prince of Wales, 10th of June, 1688.
yeah, good reference.
The bottom one was Electress Sophie of Hanover, who always maintained that the unfortunate young prince was as much the child of James II as her son George was her own offspring. Considering that it was she and her son George who were designated to inherit the crown by the 1701 Act of Settlement, this was a brave admission.
Hmm. Yeah, good quotes. Interesting.
Moving on to the case of the seven bishops, and this was the 30th of June, 1688.
Okay.
The Declaration of Indulgence was reissued in April 1688. James had instructed the English bishops to have it read in every church.
Should we just say what that is? Okay, so the Test Acts, there were multiples actually, weren't there? So they were enacted following the restoration of the monarchy in the 1660s, or just soon after, wasn't it? Following the interregnum.
Yeah,
They required people who were taking up a sort of public position of responsibility or influence to take an oath of supremacy and allegiance. I think it was called, wasn't it? Is generally
yeah,
how it's explained. And it required them to take the Anglican sacrament, which is, of course, communion. And so what this was basically doing was barring, yes, Catholics, but much more than that. You know, would have been Jews and uh, Quakers, of course, we talked about, and others who were not specifically Church of England to not only take important positions, but maybe even go to university or get into the army or things like that. So that's just a quick reminder. And James was appalled by this. It offended his sense of liberty and morality, and so he introduced in 1687, I think it was the year before this, the case of the seven bishops, the
yeah,
Declaration of Indulgence, or I think it was called the Declaration for Liberty of Conscience. They would claim, of course, the other side, that he was trying to make the country Catholic. And in some ways, you could say that he was trying to bring it towards that because he believed that that was the true Christianity in his view. But rightly or wrongly, actually, what he was really trying to do, at least to begin with, was just trying to level the playing field, and he was concerned about, liberty of conscience. So that's what he was trying to do just before that, wasn't it? Really, this was basically requiring the Declaration of Indulgence to be read out, wasn't it?
the Declaration of Indulgence was reissued in April 1688. James had instructed the English bishops to have it read in every church. The seven bishops refused and signed the petition asking to be excused from this duty. Their argument was that this duty relied on an interpretation of the royal prerogative deemed illegal by Parliament. So I've just put in brackets suspension of the penal laws and dispensation of the Test Act.
Yeah.
Before James could address the bishops, it is likely the petition was purposely leaked to the public to stir up support. The bishops were arrested and charged with seditious libel. At their trial, they were acquitted of sedition, although the royal prerogative was only addressed by one of the 4 judges in court. Judge Powell overlooked Godden versus Hales, Thomas versus Sorrell,
Yeah.
and Edward Cook's views on the dispensing power.
It will become clear as to what was going on there in a moment when we explain that background about the prerogative of the king.
Yeah.
To dispense with legislation in the case that we're about to discuss in a moment, because they ignored it in this decision, didn't they, about the bishops, basically.
Dispensing with things that are wrong by prohibition, i.e. legislation, is rightfully granted to the king on account of the impossibility of providing for every particular case, and the dispensation is a release of the prohibited wrong or a measure of necessity.
Yeah, good quote.
And the second one was a quote from W.A. Speck, Reluctant Revolutionaries. Sir Edward Cook had given an opinion on the matter, dispensation. Coke distinguished between crimes against the laws of God and crimes against the laws of man. To break God's laws was naturally evil and therefore eternally wrong. No king could indemnify a subject from the consequence of committing such crimes by royal dispensation. Man-made laws, on the other hand, are relative in time and space. They can be repealed, and therefore violation of them is only wrong while it is prohibited. Kings could therefore dispense individuals from the penalties incurred by a breach of such legislation. The opinion of the remaining 11 judges was that James had the right to dispense with the Test Act to allow individual Catholics to hold office was a reasonably sound one at law.
Yeah, it's interesting. And just to give people a little bit of background, obviously Sir Edward Cook there, we're going back into and we dealt with that chapter, didn't we, in a sort of previous chapter of the 17th century history. So we're talking back to the time of sort of James the First, and then into Charles as well. So we're talking sort of 1610, 20, 30, around that sort of time. Sir Edward Cook was around at that time, and it wasn't without its contentions, and he had some difficulties, but generally speaking, he was saying some good stuff on the whole. Reluctant Revolutionaries, W.A. Speck. Yeah, that was the book that I just held up there. That's that one, which is quite a useful source as well on this stuff. Basically, this is to do with the royal prerogative, and the royal prerogative sort of breaks into a number of different things, because it could be to do with in this particular case, what we're talking about specifically is the king's right to dispense with legislation on his books that he deems to be unlawful, according to higher law, to common law, natural law principles, common right or reason. If he feels that the laws on the statute books are creating injustice, then it's his job to sort that out and to deal with it. That's part of his governing. Remember that every coronation he takes a coronation oath, a promise to govern, and therefore it's his responsibility ultimately to make sure that on his statute books there are not statutes that are producing injustice. And James felt morally that the Test Acts were indeed such an example, and so did Charles before him as well. Parliament didn't feel that, of course, and the establishment generally were against them on that view. But that's what the kings were trying to do, essentially, was to govern the country ultimately with their responsibility. So this is, and we'll get on to the case in a minute that sort of confirms this idea. that actually the laws are the king's laws ultimately. And a lot of people, and partly it's through our programming, this uncomfortable idea that the king can have that level of power. But actually, when you think about it, what it really is it's whether the king has that level of responsibility. That's what we're really saying. Is it's not just power, it's responsibility as well. And so ultimately, in what is a hierarchy of accountability, because that's what we're saying is the government or the administration is a hierarchy of accountability. And if you are taking one individual to head that up and be ultimately responsible, then you have to give him the powers to do that governing. Otherwise, you're going to create an absolute shambles, which is what we have today, where you're saying kind of, and it's a little bit like imagine the CEO of a company. You know, if a company is failing, then the shareholders have got to hold somebody to account. Who are you going to hold to account? You're going to hold a mixture of people because you've got an obfuscated, well, who has the decision-making power of, ultimately, is it the CEO or is it the chief financial officer or is it the head of HR or is it the, that's the marketing guy or whatever it is, and actually suddenly everybody has bits of the power. Well, no, it doesn't happen like that because you'd have absolute chaos. Ultimately, it's the CEO you hold to account if the company is failing. Well, it's the same with an administration. That's the way the rule of law was supposed to work, is that the king has the ultimate responsibility. But you still hold them to account. It doesn't mean to say that they don't have that ability to be held to account. Yeah, and in the case of the administration in our rule of law, that is basically bringing the king to trial. If you feel you have a case where he's been immoral, where he's worked against God's laws, it's quite simple, really. This is the king operating with his powers to say, no, this piece of legislation is unjust, and I'm going to suspend it or repeal it entirely. And so what we're seeing here is the fulfillment of the rule of law as it was at the time, quite correctly, in my view.
I suppose Cook explains that quite well, to be honest,
I
because
think he does.
the
Yeah.
way he talks about God's laws, saying it doesn't matter what legislation you've got in place, if you ultimately breach natural law, it's a
Exactly.
breach and that's it. It doesn't matter. So
There's an important distinction here, and this is what came about, and I hinted at it earlier in the divine right of kings. And the divine right of kings kind of slightly mischaracterized the king under God. It wasn't basically saying that the divine right of kings wasn't that the king could just do anything he likes. It's not that at all. It's saying that the king is under the law as well, is
yeah,
under God's law. But what it's saying is that it's ultimately we're giving the king, because we've elected the king, hopefully, maybe not. He has the ultimate responsibility to decide on man's laws, on our approximations, our statutes, and it's his responsibility to make that happen. That's what we're saying, and there's a distinction there. So what Cook is rightly saying is that the king still falls under the divine laws of creation, of God, of common right or reason, if you want to put it that way. Yeah.
the Test Acts was a breach of people's rights, free.
Yes.
It was a breach of natural law as well, if we want.
Yes.
So,
Yeah.
if we're talking about whether we say natural law, God's law, universal law, it doesn't matter. We're still referencing the same thing.
Yeah.
It was moral, wasn't it? And not only that, I don't think James II was just going around suspending all kinds of legislation.
No.
This was a religious matter as well, under the Church of England, which he was the head of. In his coronation, he was bound by God's law. It says in the coronation text, and it also says the laws that the kings granted.
Yes. Correct. The legislation on your statute books must be in alignment with our sense of conscience, our sense of right and wrong. Absolutely right. Yeah.
And if it's the king's legislation and it's breaching morality and it's breaching natural law, then he has every right to dispense with it or to suspend it.
He has not only a right but a duty as well.
This is the first case. It's not the Godden versus Hales,
Yeah.
but it's important because it mentions the dispensing of legislation. This was Thomas versus Sorrel, 1673. And surprised that you'll like this, Will. Lord Chief Justice Vaughan, and it was a dispute over licensing and the dispensation, the power of dispensing with legislation. That's interesting, Will. It was Justice Vaughan.
Justice Vaughan, yeah. So we should mention, of course, 1670, not that long before. Bushel's case that we talked about with William Penn, re-establishing, not establishing for the first time, re-establishing the principle of jury independence. So it's the same justice, Chief Justice Vaughan, absolutely.
A case later in the 17th century, however, qualified Cook's opinion. This involved a member of the Vintners Company who sold wine by retail without license. An informer took him to court in 1673. Vintners claimed that James I had granted a dispensation to members of the company to sell wine without having to hold licenses for that purpose. The Lord Chief Justice, however, found against him. He referred to Cook's distinction between crimes which were inherently evil and those which were simply infringements of statute law. He agreed that the king could dispense with the latter in most cases, but when a dispensation damaged the interests of a third party, it was invalid. The Vintners dispensation gave them an unfair advantage over other wine retailers who had to pay for a license. So that was from Reluctant Revolutionaries, W.H. And what's important is that the judgment included that the king could dispense with statute law.
Yes, exactly right.
The only reason why he couldn't dispense with it would be if it affected a third party.
Yes, this is moral. This is basically what we're saying. We have to be and you never know how it's going to turn out. You can't create sort of like broad brush. Well, you can create sort of broad brush principles, but you can't legislate for the procedures and the. Yeah, you have to just take each situation as it comes and consider it morally, which is the sort of organic nature of our constitution.
The second quote is again from Reluctant Revolutionaries. This was the latest exposition of the law before the Hales case. Neither Cook nor the president of 1673 clearly invalidated the dispensation granted to Sir Edward by James II. It was not against the law of God, even in the 17th century England, for Catholics to hold office under the crown, nor could any third party sue Hales for damages arising from his obtaining a commission in the army.
Okay, so we're starting to make reference to the next case here, aren't we? Which is where James II appointed a Catholic into his ranks of officers in order to put down the Monmouth Rebellion, which we talked about in the last part, didn't we? Yeah. And he needed to do that. That was basically just so that makes sense, that bit there.
This was the judgment of Chief Justice Herbert, who presided over this case, Godden versus Hales. King's Bench, 16th of June, 1686, and this was a reported breach of the test.
It was during the Monmouth Rebellion, which was the Duke of Monmouth, who was the illegitimate son of Charles II, declared himself king, just as a reminder of what we talked about in the last one. And James's efforts in order to put that down, put the rebels down, he appointed Sir Edward Hales, who had recently converted to Catholicism, as an officer in his ranks. And that act basically contravened the Test Act, as I sort of hinted at just now. This case is basically all about that. So Mr. Godden brought legal action against him on behalf probably of the Protestant establishment, essentially. But what this was really about was more about whether the king could temporarily nullify or suspend a statute in certain situations, as we hinted at just now. This is known as the king's dispensing power, or part of the king's prerogative powers. So take it away, Damien, on that one.
Can I just add to that, Will, that
Yeah.
in the Test Acts, I think there was a clause that rewarded people for informing on others who had failed to take
Good
the
point. Yeah, I've forgotten that. Yes, exactly.
There is no law whatsoever but may be dispensed with by the supreme lawgiver, as the laws of God may be dispensed with by God himself. So likewise the law of man may be dispensed with by the legislator. For the law may either be too wide or too narrow, and there may be many cases which may be out of the conveniences which did induce the law to be made, for it is impossible for the wisest lawmaker to foresee all the cases that may be or are to be remedied, and therefore there must be a power somewhere able to dispense with these laws. But as to the case of simony, that is objected by the other side, that is against the laws of God and a special offence, and therefore malum in se, which I
Insane.
do agree. Which I do agree, the king cannot dispense with. What does that mean, Will? Does that mean evil
I'm
in
just checking.
Latin? I think it means evil in Latin.
Yeah, I think it is. Yeah, some sort of wrongdoing, isn't it? I think. Simony is the act of selling church offices and rolls or sacred things. It's described in the Acts of the Apostles as having offered to disciples of Jesus payment in their empowering him to impart the power of the Holy Spirit to anyone on whom he would place his hands. But as to the case of simony that is objected by the other side, they would be claiming that the king is trying to suspend something that is inherently lawful. So the other side are claiming that it's right that the Test Act is in place because there are certain religious standards that have to be upheld. So it's a bit tricky because this is to do with their belief in the Test Act as being fundamental to creation. They would try and use these arguments that the Test Act is correct because unless you're taking the Protestant, the Church of England communion, and then you are outside God's laws. What we've got here is the idea of religious toleration being a more foundational principle than whether or not you're taking the character of your religion and the way that you're taking the bread and wine and the way that you're so this is the problem, isn't it? And of course a big part of the country fundamentally believe that.
It's the whole persecution of dissenters, Catholics, all dissenters, is completely immoral.
Yes, and so this is the point that's got to be made here, I suppose, is that the king took the view that even though you think that your religious convictions are more important to God, actually what is more important is religious toleration. That actually we are a people that is in this country of mixed religions. We are of mixed faiths, mixed denominations, and some people even secular, perhaps. And therefore, to deny people their basic, fundamental rights is more offensive to God than whether or not they're taking the right kind of communion. That's what James is saying, I think. Isn't that what we're saying?
If legislation is breaching God's law, I have every right to annul it because it's against morality.
They would be saying that piece of legislation should be in place because God's law dictates that you take the right kind of communion. What they're trying to do is to balance one against the other, but I think James is right in that a more foundational kindness or morality is ultimately that you don't deny essential fundamental rights to people. like going to university or being in the army, or you know, um, that shouldn't, you know, the right kind of communion, whether you believe that or not, is not going to affect your job as an officer in the army.
Catholics had been persecuted
Yeah,
and left out of even things like education for 3 generations. A
yeah.
lot of them wouldn't have been capable of holding office and doing a decent job. There was no way he was going to replace all Protestants with Catholics.
He was trying to bring about a condition of equity. And so there is a situation where he understood that. I mean, this is going back. I don't know whether I mentioned about Stephen Langton. So I've just been looking into that more closely at the situation around the 1215 Magna Carta. And what is very interesting, of course, about Stephen Langton, who was fundamental in penning that document, is that he was prepared to go against the Pope at the time in support of fundamental liberties, in understanding the principles of justice and common right and reason, which is that phrase I seem to be taking on more and more now. So he was prepared to suspend his connection with the Pope on that basis, because he felt that the condition within England at the time was more a matter of fundamental rights and individual rights, and he was prepared. So that's about natural justice. So he's saying foundationally, I've got to support natural rights and natural justice more in this situation than my connection with the higher aspects of my religion, which is the church, my connection with the Pope, etc., etc. He's prepared to break that connection on that basis. So here, in a way, is a similar situation where James is prepared to raise the importance higher of principles of fairness and justice and toleration and fundamental rights. And that's what this is all about, really.
Chief Justice Herbert adjourned the case to bring in other judges to comment on this case, to make a decision on it. So
Yes,
there was 12 judges in all, and 11 agreed with
indeed.
Justice Herbert on his call of that case, which is at the bottom, and I'll read out. So there's 5 parts to this. Number 1, that the kings of England are sovereign princes. Number 2, that the laws of England are the king's laws. Number 3, that therefore 'tis an inseparable prerogative in the kings of England to dispense with penal laws in particular cases and upon necessary reasons.
Necessary reasons, absolutely key.
Number 4, that of those reasons and those necessities, the king himself is sole judge. And number 5, that this is not a trust invested in or granted to the king by the people, but the ancient remains of the sovereign power and prerogative of the kings of England, which never yet was taken from them, nor can be.
It's brilliant. And actually, you know, this is propping up what we were saying earlier, that the rule of law at this point is basically based on the idea that your head of state takes a promise to govern the nation, and they have that full response. I mean, who the hell would take on that level of responsibility? You know,
Yeah.
and that is a massive responsibility. It's more about a massive responsibility than a massive power. The only thing I would say in that is that the second last line, number 4, that of those reasons and those necessities, the king himself is sole judge. Now, yes, that's true, but the caveat would be in that situation that he should hold court at that point in his decisions, so that he should take counsel from those high-ranking justices and people around him, his peers, in order to be able to make those decisions, just as happened in the Saxon times with the Witan. Yeah, so he's taking advice and taking counsel. And if repeatedly the king is making autocratic decisions without agreement from those people around him, then you would have a situation where his peers, a different lot, I suspect, from the issue that he disagrees with, should then bring him to account under a trial if that's happening on a repeated basis and there's good evidence for that. Yeah, but as much as possible, the king should take good counsel and not be seen consistently, at least, to be making sole decisions. But if it can be shown that he's making a sole decision based on good reason and morality and good conscience, then there may be a situation where he's having to do that against other situations that are occurring. Quite clearly, they are in this situation here.
And it is important to say that he wasn't just suspending legislation left, right, and centre to suit himself. This was a religious matter, and it was a matter of morality as well.
Yeah, and you're right, and that would be brought as evidence before his trial, if there was a trial that had to come about for that. Is that, that would be part of the evidence that, well, are you doing this generally? Are you suspending legislation on a massive basis? Or, interestingly, that if we had a situation right now and the king stepped up into his role, and he would need the support of the people to do that, by the way, not constantly saying to the king, don't get involved in politics. You either do want the king to get involved in politics or you don't. If he's got a royal prerogative and he's taken an oath to govern the country, don't keep criticizing the king for getting involved in politics. You can't have it both ways, right? But where was I going with that before that little mini rant? But I suppose what I'm saying is that, the king has got to have that general kind of groundswell of support from the people, that if there's something that the king needs to step up into and do, then he must be able to do it by that very visual and audible support from those around him.
As long as that check is in place.
Exactly.
Trial by jury, if he is abusing his powers.
Precisely. Yes.
There isn't any issue with the king dispensing with his own laws, as long as it's in alignment with natural law and with morality and with the Constitution.
Exactly right. It's got to work like that, because otherwise, who do you hold to account? The situation right now is just an absolute nightmare, because nobody quite dares to say, well, who's ultimately responsible for that or that or that. It's just a lot of obfuscating and kind of gaslighting and fudging of the issue. Does the king actually have ultimate responsibility or not? All your oaths of office are taken to the king, or most of them. So why do you do that then? Why do you have the king taking a coronation oath, and you say that he's ultimately governing the country, but then, well, actually he's not really. Well, either he is or he isn't, and how is it that you are then also denying him his powers if you're asking him to govern in his promise? It doesn't make any sense. The only way the authentic constitution can actually work is to place the king fully in his position of responsibility to do what he needs to do, making sure that he promises to do that, and then hold him account when he's consistently out breaching law, breaching the grander law, the creation's law. Reason and logic and good conscience.
I just find it all strange, especially what's going on today, because even when you talk about like the topic of royal assent comes up, it's like, oh, that's a formality. If the people have any issues, they're petitioning the king to make it right.
Yeah, absolutely. It's a bit more obfuscation again, because what you often hear, even in the training of lawyers, is this well, does the king have royal assent powers? Well, yeah, technically he does, and here's the bit, but he wouldn't use them.
Judgments I took from the Stuart Constitution, that was J.P. Kenyon.
Just to finish off there, so what we're seeing is repeated judgments in support of how the old rule of law is supposed to work, in support of the idea that the king does have a right and a duty and a full responsibility for the statutes on his statute books. Absolutely.
That, like I said earlier, falls in line with his coronation oath.
All's in line with the coronation
There
oath.
was no mention of statutes or suspending powers or anything like that in the coronation oath. There is another couple of quotes. That this first one is again, it's taken from the Stuart Constitution, and it was J.P. Kenyon.
Canyon, yeah.
The accession of a Catholic monarch in 1685 exacerbated the whole problem, and James II's dispensations to Roman Catholic army offers, relieving them of compliance with the Test Act, roused a storm in the House of Lords in November 1685. There was a growing feeling that though the king did possess a power of dispensation, it should not be applied to statutes which imposed a religious test or qualification. In Godden versus Hales, the judges decided that no such distinction existed. Herbert adjourned the case to take the opinion of the judges of Common Pleas and the barons of the Exchequer. Of the other 11 judges, all but one fully concurred with him. The second one is a quote from Lord Chief Justice Herbert himself. Whatever is not prohibited by the law of God and was lawful before any act of Parliament made to forbid it, the king by his dispensation granted to a particular person may make lawful again.